important judgment by Honorable Supreme Court in the case of Radhika Agarwal, wherein Honorable Supreme Court has upheld the constitutional validity of arrest provision under the GST law and custom law with robust safeguard. This judgment is of 73 pages. 279 petition was filed. A batch of petitions is being decided jointly. There are 7 important pointers which we should know. We have seen in GST law and custom that recovery is being made under threat of arrest. Sometimes we look for the answer of anticipatory bail. Sometimes we question whether arrest can be made without warrant. What is the difference between cognizable and non-cognizable offense? So I've created 7 important pointers which is decided in this judgment. So we will discuss the issue and held position for easy digest. I'm sharing one document which will help us to understand what was the issue before the apex court and what is being decided by Honorable Supreme Court. If you look at the first point, legality of arrest power under the custom provision and under the GST provision. And it is all being evaluated post Om Prakash apex court judgment, which came in the context of custom law. But this is what the first question before the apex court, whether custom and GST officers can arrest without a warrant for cognizable, which is called non-bailable offense. Post Om Prakash, and whether such power align with the constitutional safeguard. This was the first question. Answer: held. Honorable Supreme Court has held that amended arrest power under Section 104 of the Customs Act 1962 and Section 69 of CGST Act are correct, constitutionally valid. If you look at the GST law under Section 69, a commissioner having reason to believe he can pass an order for arrest of any person who has committed the specified offense under Section 132, subsection 1, clause A to clause D. A talks about supply of goods or services without invoice. B talks about issuance of invoice without supply of goods or services. C talks about when you avail credit on such invoices without supply of goods or services, or you're availing credit without having any invoice or bill. And clause D talks about any amount collected as a tax but fails to pay beyond a period of 3 months from the due date of payment of tax. If amount of tax evaded or wrongly availed credit or utilized credit or any erroneous refund is more than 5 crore, it is called cognizable or non-bailable offense. So this is coming from GST law provision. If you go to Custom 104, then it talks about any tax evasion of more than 50 lakh or you're dealing with the prohibited goods. It is called cognizable offense. In such cases, issue was post Om Prakash judgment whether arrest can be made without warrant, and constitutional validity was challenged before the apex court. Honorable apex court has held that post Om Prakash, certain offenses like custom, as I said, and 5 crore under GST law for the cognizable and non-bailable offense, allowing arrest without warrant if the officer has reason to believe based on credible material, and relevant paras of the judgment are also being quoted for each of your reference, para 7 to 11, para 58 to 60. Having said that, next question, next issue, constitutional validity. Whether section 69 power to arrest and section 70 summoning power, issuance of summon by GST officer under the CGST Act are constitutionally valid under Article 246 capital A. Given the petitioner's contention that criminal provisions exceeds Parliament GST legislative competence. So this was the issue which was decided by Honorable Apex Court. Challenging to section 69 and 70 was rejected. Para 72 to para 75 of the judgment can be looked at. The court held Article 246 capital A grant Parliament comprehensive power to legislate on GST, including ancillary power to prevent evasion through arrest and summon. These provisions are within legislative competence and align with the doctrine of pith and substance. So this is being held valid, constitutionally valid. Next question was, if it is constitutionally valid, what are the safeguards against misuse of arrest power? Of course, taxpayer is demanding that we have seen under the threat of arrest, department is pressurizing, and under coercion, they are recovering taxes. So this misuse of arrest power, what are the safeguards? Issue watch. What safeguard must be followed to ensure arrest under these acts, means Custom Act and the GST Act, do not violate personal liberty, Article 21, including requirement of reason to believe. Even section 69 talks about when commissioner is having reason to believe. So what is reason to believe? Informing ground of arrest, which is required as per the instruction issued by CBIC, and preventing coercion for tax payment. This was the issue what is being held by Honorable Apex Court. Apex Court mandated strict compliance with the safeguard. Yes, arrest power are constitutionally valid, but robust safeguards are being stated in this judgment. What are those? First, officer must record reason to believe, must record on note sheet based on explicit credible material, para 24 and para 59, unless there is reason to believe which is explicit and credible, arrest cannot be initiated. This is what the safeguard. Second, arrestees, the person who gets arrested, must be informed of ground of arrest in writing, not verbal, in writing, per Article 22, Sub-Article 1, and the guidelines as provided in the DK Basu case must be followed. Relevant para is 25, 26, and 62. Custom officers, though not a police officer, must maintain records akin to case diaries, para 19 and para 23 of the judgment, and judgment is of 73 pages and different paras. Relevant paras are being quoted here for your each reference and digest. Arrested person have the right to meet an advocate during interrogation. This is the question we asked at several occasions. Whether arrested person have a right to meet an advocate during investigation or interrogation? Yes, within visual distance, but not hearing distance. Para 26 and para 27. Court has also endorsed, Supreme Court has endorsed CBIC instruction number 2/2023, dated 17th of August 2022, requiring justification for arrest beyond the legal prerequisites. There may be requisites to arrest, but there should be justification for arresting a person, such as risk of tempering evidence or absconding, para 61, and also endorse instruction number 1 of 2223 dated 25th May 2022 on deposit of tax during the course of search, inspection or investigation. We have seen the provision 73 subsection 5 non-fraud case, 74 subsection 5 fraud case. There is no provision within the GST law for the advance payment of GST, but voluntarily, if you determine as a taxpayer you are liable to pay, you can deposit, but nothing can be recovered under coercion, under threat of arrest. And that is what these two instructions are being endorsed and relied upon. Next question was judicial review. To what extent court under Article 32 for Supreme Court, under Article 226 for the High Court review arrest under special statute, because GST law is special statute, custom law is a special statute. Can it be put under judicial review, particularly regarding sufficiency of evidence or subjective satisfaction of arresting officers? Now, this question is really important one. What is the level of sufficient? On what level the officer is arresting a person? Can it be put under judicial review under Article 32 for Supreme Court, under Article 226 for the High Court? And Honorable Apex Court Justice Tribedi emphasized, who was one of the bench member, emphasized limited judicial review, pages 64 to 76. Courts should intervene only in case of manifest arbitrariness, malafide intent, or statutory non-compliance. Example, lack of material or failure to inform ground of arrest. Then it can be put under judicial review. The sufficiency of material or officer's subjective satisfaction is not, please, is not reviewable at the investigation stage. Para 9 and 10 of the judgment can be looked into. Next, precondition for arrest. What are the precondition? And for precondition, whether assessment order need to be passed under section 73 or 74. So this is the question we are normally asking, and this was the question before Apex Court also. Whether arrest under CGST Act require prior arrest order, prior assessment order under section 73 or 74. So question is whether any prior assessment order is required before initiating arrest provision under the GST law, or if arrest can be justified based on credible material indicating a non-bailable offense, what is being held by Honorable Supreme Court. The court rejected, I'm saying that court rejected the petitioner's contention that arrest under GST Act require a prior assessment order. So no need of passing any assessment order. No prior assessment order is required for arrest provision under the GST law. Arrest can proceed if there is sufficient certainty of non-bailable offense under section 132 subsection 1 clause A to clause D, which I have said in the beginning of this video, provided regions are recorded, para 59. However, benefit of doubt applies and arrest should not be routine. This is what the safeguard provided. Now, can you go for anticipatory bail? which is available under section 438 and 439 of CRPC. When arrest under the GST law, can you go for anticipatory bail as per section 438 and 439 of CRPC? Possible. So this was a question even without an FIR, based on reasonable apprehension of arrest. So maybe a taxpayer is having apprehension of arrest. Can he move anticipatory bail application? Answers by the apex court. Anticipatory bail under section 438 and 439 CRPC applies when there is reasonable apprehension of arrest even without an FIR, as per Guru Baksh Singh CBR and Susila Agrawal, para 70 is important. Contrary GST specific decisions were overruled. So wherever it is being stated that under the GST law, you can't go for anticipatory bail, those judgments were overruled. The last important pointer, coercion allegation. We have seen lot many times under duress, under coercion, under threat of arrest, tax is being recovered. Tax is being recovered by the tax officer. Whether that is possible and permissible. Issue, the same issue, whether practice of compelling tax payment during investigation and the threat of arrest violates legal and constitutional norms. Answers. Apex Court has said the court found merit in allegation of coerced tax payment. So they found merit that this is happening as on date in the market. Para 63 to 67. Recovery requires adjudication. So they are saying recovery under the GST law, it's permissible only when there is adjudication order, and only from the date after the 3 months time period from the adjudication order, recovery can be initiated under section 79 of CGST Act. Not coercion during investigation. So recovery can be initiated only when adjudication order is being passed and 3 months is being elapsed. Voluntary payment under section 74 subsection 5 in all fraud cases are permissible, voluntary by the taxpayer, but must not involve force. SSC can seek refund if coerced and officers face actions for violation. So here the safeguard provided to us. In case you as a taxpayer depositing the tax voluntarily, no problem. But if it is being under duress, under coercion, under threat of arrest, then you are having your own right to go for a refund. And that is what these paras, relevant paras, which I referred, para 63 to 67 and para 68 of Apex Court, this Radhika Agarwal judgment is talking about. Other two observations, the court declined to examine. So this question was not entertained. Court declined to examine section 135 of CGST Act, which is pertaining to culpable mental intent. Simple meaning, क्या टैक्सपेयर के माइंड में कोई मेंस्ट्रिया था? This is what, as no prosecution were initiated. So section 135 is not dealt with. Para 76. Connected matters were listed for final hearing from March 17, 2025, para 78. So this document is being made, which is there in the description box, where we have summarized the 73 pages of Honorable Supreme Court judgment Radhika Agarwal and summarize the important pointers. And these pointers we have done through video also. So that will help you. You can download this document for each of your reference. And this will help you to take note of important provision constitutional validity of arrest provision with robust safeguard wherever tax recovery is being made under coercion, under duress, it is not permissible. Anticipatory bail is permissible under CRPC. Lot of important factors which you look for the answer, this judgment will provide. To my mind, this judgment is a balanced judgment. Of course, upholding the constitutional validity, but also providing robust safeguard to the taxpayer. Thanks for watching. Stay tuned. Thank you very much.